12 of the National Prosecuting Authority Act on the 18th of June last year. It is imperative in terms of the Constitution that the prosecuting authority must exercise its functions without fear, favour and prejudice. This obligation is repeated in Section 32, subsection 1A of the National Prosecuting Authority Act, which reads, open quote, "A member of the prosecuting authority shall serve impartially and exercise, carry out or perform his or her powers, duties and functions in good faith and without fear, favour or prejudice, and subject only to the Constitution and the law." Close quote. Section 32, subsection 1B of the NPA Act further reads, open quote, "Subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its of her power, duties, and functions." Close quote. In terms of Section 20, subsection 1 of the National Prosecuting Authority Act, which is echoed by Section 179, subsection 2 of the Constitution, open quote, "The power as contemplated in Section 179, subsection 2 of the Constitution, and all other relevant sections of the Constitution to A. Institute and conduct criminal proceedings on behalf of the state, B. Carry out any necessary functions incidental to instituting and conducting such criminal proceedings, and C. Discontinue criminal proceedings, vests in the prosecuting authority and shall, for all purposes, be exercised on behalf of the Republic." Close quote. It is well known that on 6 April 2009, the Acting National Director of Public Prosecutions at the time, Advocate Mshe SC, announced his decision, taken on 1 April 2009, to discontinue the prosecution against Mr. Zuma, who was President of the African National Congress at the time, but not yet President of the Republic of South Africa. Whilst I was a member of the NPA at the time, I was neither involved in guiding the investigation, the decision to prosecute, nor in the decision to withdraw the charges. I came to know of the decision when the general public was so informed on 6 April 2009. On 29 April 2016, the full bench of the Pretoria High Court set aside the decision of Advocate Mshe of 1 April 2009 to discontinue the prosecution of the case against Mr. Zuma in accordance with the indictment served on Mr. Zuma on 28 December 2007. The effect of the decision of the High Court is that, absent an application for leave to appeal, it falls upon me as the National Director to consider the matter. I have read the decision of the full bench of the Pretoria High Court, and I have considered whether it is a matter where application for leave to appeal to the Supreme Court of Appeal, and if there are grounds to do so, should indeed be brought. I have taken legal advice from senior counsel and junior counsel and from senior members of the National Prosecuting Authority, particularly in regard to the High Court's findings and the bases thereof. I regularly read print and electronic media reports, and when time permits, I listen to radio, and I too watch television broadcast news. It would be naive for anyone to think that I am not aware of the calls from certain sections of the citizenry to proceed with the prosecution. There are, of course, equally calls that I should not do so. I wish to make it absolutely clear that I will carry out my duties and my obligations in all cases, irrespective of who the suspect is or who the accused may be, without fear, favour or prejudice. I will only do so in what I believe is correct and proper in fulfilling my constitutional obligations and those imposed upon me by the National Prosecuting Authority Act and any other law. In the present matter concerning President Zuma, whatever decision I make will no doubt elicit criticism from some or other quarters. No decision will please all of the people, yet it is not in my job to seek to please anybody or make popular decisions, but only to act in terms of the principles and policy and in accordance with my constitutional and statutory duties. I will always do what is correct, irrespective of whether the individual concerned is an ordinary citizen, a cabinet minister, or a sitting president, and regardless of the person's station in life. If there is any suggestion that I may have succumbed to any pressure in making my decision, I can assure the public today that it's absolutely ridiculous and completely unfounded. My decision has been made after much consideration, consultation with senior members of the National Prosecuting Authority, and after obtaining legal advice from senior counsel. The High Court found that Advocate Mshe, the then acting National Director of Public Prosecutions, should not have taken it upon himself to discontinue the charges in light of the prosecutorial misconduct. The High Court found that Advocate Mshe should rather have allowed the issue to be ventilated in court. This means that the head of the National Prosecuting Authority may not take it upon himself or herself to determine that the abuse of process was so egregious as to warrant discontinuation. The National Director has, after all, taken an oath to protect and defend our Constitution. The National Director's duty is to protect the institution and integrity of the Constitution. It is the National Director, I believe, who is best positioned to weigh the seriousness of abuse within his or her own hierarchy. If, as here, the National Director misconducts himself or herself in the internal review of a prosecution, it is always open for the matter to be taken on review. Sight must not be lost of the tried principle that a prosecutor is vested with a very broad discretion. The public interest, and not the wishes of the public, must always factor in his or her determinations, to the extent that it is not obligatory that every person the prosecutor considers guilty must be charged. Nevertheless, the High Court has decided that where there was misconduct, as in the present case, the present matter should have been taken to and argued before court. In my view, if this is now general principle, then prosecutors are denuded of much of their powers. Article B of the Code of Conduct for members of the National Prosecuting Authority reads, open quote, "The prosecutorial discretion to institute and to stop criminal proceedings should be exercised independently in accordance with the prosecution policy and policy directives, and be free from political, public, and judicial interference." Close quote. In terms of Article 3 of the prosecution policy, the prosecutor has a discretion to make decisions which affect the criminal process. This discretion can be exercised at specific stages of the process. In principle, the judgment also affects each and every person who is the subject of a prosecutorial consideration, and the discretionary powers of the prosecutor, which is exercised on a daily basis and at various stages of the process. The judgment of the full bench of the Pretoria High Court is also a matter that seriously affects the separation of powers. This is an important matter of principle which affects all prosecutions. It is so important, I believe, it needs the decision of an appeal court. It has far-reaching ramifications for the powers of the institution and for the very citizenry of our republic and our young democracy. Whilst the issue arises in a high-profile case, it is the only decision on this point, and I believe, with respect to the High Court judgment, that it should be considered by an appeal court. I should mention that this, of course, is not the exclusive ground upon which leave to appeal will be sought. In the circumstances, as appears from what I have said, I have decided to apply for leave to appeal against the judgment of the full bench of the Pretoria High Court. There is considerable public interest at stake herein, and the issues are of great constitutional import. I have instructed the State Attorney to file the necessary papers this morning. As I stand before you today, I reassure you of my commitment to my oath of office to uphold, protect, and defend the Constitution and the fundamental rights entrenched therein, and to enforce the law of the Republic without fear, favour, and prejudice, and to do so vigorously as the circumstances of any particular case may require, and in accordance with the Constitution and the law. I thank you.